one of the more outspoken voices against the persecution of Julian Assange, who visited Assange in Belmarsh prison with a team of doctors and said that Julian showed all symptoms typical for prolonged exposure to psychological torture, is Nils Melzer. He is a professor of international law and also the United Nations Special Rapporteur on Torture. He joins me now. Thanks for coming on the show, Professor. It's good to have you.
Thank you for having me.
Professor, can I get your initial reaction on Julian Assange's bail being denied by Judge Barretzer? What are your thoughts on that?
Well, unfortunately, I have to say I'm not surprised. I guess Monday's decision to refuse his extradition was initially surprising. I think on second thought, it is not even that is so surprising, because it could also be quite a malicious move to reduce, let's say, the issues that can be discussed on appeal to a medical issue, and then allow the US basically to just make diplomatic assurances as to the treatment that they will give to Julian Assange in the US, and thereby can circumvent a full discussion of all the issues that have been raised in court by the defense. But the short answer really is that Julian Assange should never have been in Belmarsh from the beginning. He has been arrested. If the UK insists on putting him in prison for a bail violation 7 years earlier, which is completely exceptional. It never happens in the UK that you go to prison for a bail violation unless you committed a crime during that bail violation. But bail violation itself is an administrative offense. So no one goes to a high security prison. And, we have to understand that high security prison detention is something extremely expensive. You only do that because to people that pose an imminent security threat. And Julian Assange obviously is a non-violent, publisher. He has been put there not because he is a security threat to anyone in terms of violence or criminality, but because he was put there to be silenced. Because obviously in a high security prison, you have a very strict security regime. You can limit visits, you can limit communication, you can limit access to, internet, to working tools and so on. And that's exactly what was the intention. So to keep him there from the beginning has been unnecessary. It has been disproportionate. Once he had served his sentence, he was, since September 2019, he's there only for preventative purposes to ensure his availability for the extradition proceeding. Others have been held in house arrest for these types of things. Even former Chilean dictator Pinochet was held in 1.5 years in house arrest in the villa, received visits by the former prime minister. Well, could you imagine Julian Assange being held in a luxurious villa and receiving visits from Tony Blair? I don't think so. But I'm making this caricature not because it's funny, but because it illustrates how unbalanced this prosecution has been, and that this has never been about the law. It's always been about politics and about silencing him, and not about prosecuting him for anything he's done.
You initially welcomed Barretzer's decision on Monday that she ruled against extradition. However, you noted, as did I and a few others, that while it's good she ruled against extradition and she accepted the opinions of the medical experts and the risk of suicide, she agreed with everything else in the indictment, that while it's good for Julian, it's not exactly good for press freedoms. Could you elaborate on that?
Yeah, I would even be more cautious about whether it's that good for Julian Assange. It looks good on paper because we don't know yet what's going to happen in the appeals phase. But first of all, yes, obviously, I agree that he cannot be extradited to the US because he would be inhumanely treated there. And that's something that I said already on the 5th of April, 2019. He was still in the Ecuadorian embassy. And I called on Ecuador not to expel him because of precisely that risk of ill treatment and torture in detention conditions in the US. Supermax conditions are recognized not just by me, but by my predecessors, by Amnesty International, basically everybody who's dealing with human rights, acknowledges that Supermax detention conditions, especially under the so-called special administrative measures, amount to torture and other ill treatment, which is absolutely prohibited under the Convention Against Torture. So you can't extradite a person towards a country that practices these types of detention conditions. And the US has been quite, open about the fact that that's precisely what they would be doing to him when extradited. So on that account, yes, her decision actually confirms my assessment as to the risks of torture and ill treatment in the US. And certainly that is something I can only welcome. However, it also confirms, by the way, my assessment my conclusions that I came to together with the medical team when I visited him in Belmarsh prison in 2019, that his health had deteriorated dramatically, precisely as a direct consequence of the persecution that he was exposed to. Now, that obviously the judgment doesn't say explicitly, but it actually implicitly recognizes it, because Julian Assange was not born fragile. He is an extremely resilient person. Anyone who has met him can confirm that. And the fact that he is still alive today is actually the living proof of a very strong resilience against ill treatment. So in a sense, the judgment confirms what has been done to him implicitly. It explicitly confirms that he cannot be extradited to the US for the risk of torture. But then technically what happens is obviously that all the other issues, the whole rationale that underlies the US prosecution has been confirmed point by point in a quite outrageous way, really. I mean, it was confirmed that, based on no evidence, that this US prosecution is not of a political nature, although the contrary is really, absolutely evident. It has been the argument that he could not be that he cannot be extradited because espionage is a political offense has been denied, has been rejected, although espionage is the quintessential example in any law school of a political offense. All the defense arguments have been dismissed. Even the fact that he has been unlawfully surveilled in the embassy, the judge somehow implied that there could have been a justification to surveil Julian Assange's confidential conversations with his lawyers, and that would not be somehow making the whole prosecution arbitrary. And so if you see this point by point, she confirmed that what Julian Assange has done, which essentially is just publishing secret information he has obtained, he's not stolen, he's obtained, just as any other journalist, that could amount to espionage. And not only that, she went further. She said it would also violate the British Official Secrets Act. So she set a precedent for the UK jurisdiction and the US jurisdiction that allows the prosecution of investigative national security journalists based on espionage charges, and in both countries precludes a public interest defense. That is, I cannot overstate how dangerous that is. And now, had she then granted extradition, it would have been more, easier for Assange's legal team, because then they would have appealed, but all the arguments would have been reviewed again by the higher court. Now, because she refused extradition, but on a technicality, only because of Julian Assange's personal medical state, not because there's anything wrong with the US prosecution case. So she set the precedent, she's confirmed it, expanded it to the UK, and refuses extradition based on the technicality, which can be overturned at the High Court. But the High Court now will only discuss this particular question, unless Assange's legal team also appeals. And so if that can be overturned because the US, for example, in the appeal proceeding says, all right, we take into account the concerns of the British judiciary and we make diplomatic guarantees that Julian Assange will not be subjected to special administrative measures. But they will find a different way of putting in solitary confinement. Then the High Court could say, well, the argument has been removed, the obstacle has been removed, we can now grant extradition, and we're not even discussing the other points anymore because no one has raised them at the appeal stage. And so we've set the precedent, and the extradition can still go forward. That's the worst case scenario. And if you allow me, the second worst case scenario, and unfortunately, in my mind, still there are only worst case scenarios, the very worst ones and the little bit less worse one. The little bit less worse one is that his extradition really will not be granted. It will be refused, and he will eventually be released after the appeal stage. But on this technicality of his medical state of health. And that only means also that once his health improves, the obstacle could be removed and he could start all over again, because the US indictment is still valid, it's still there. It also means that as soon as he leaves the UK, for example, he travels to any neighboring country, the US could again make an extradition request there because the judgment is only binding for the UK authorities.
Thank you for making those points, particularly with the OSA, because it was mentioned in the judgment, and it was really shocking to me how she expanded that into British law. So thank you for clarifying it. We heard today about that offer that Assange received from Mexico, and this was misquoted because the prosecution tried to assert that he would just run away, he could just walk into an embassy and seek asylum. So I wanted to ask you something, because Assange's detractors, a lot of the smears we hear, and this was again echoed by the prosecution and the judge, is that Assange jumped bail in 2012. Well, he sought asylum, political asylum, in the Ecuadorian embassy. You're a scholar and a professor of international law, so could you maybe settle this for us once and for all about the precedents that international law and his asylum request take?
Well, you see, anyone who is politically persecuted and seeks asylum is trying to evade justice. I mean, you can look at it that way. After the Tiananmen massacre in Beijing in 1989, we had the leading Chinese activists. They sought asylum, diplomatic asylum, in the U.S. embassy in Beijing. And did they abscond? Did they evade Chinese justice? Yes, they did. I mean, to be very extreme in an example, the Jews that were hiding from the Gestapo, did they evade, Nazi justice? Well, yes, formally they did, but it's absolutely absurd to make that argument. I mean, that's the very point of asylum, is that you're trying to escape an unjust regime. So the question really is, can the asylum seeker leave his or her asylum without being exposed to grave violations of human rights? Now, that's precisely what has been proven, that Julian Assange could not rely on that. The first day, it has always been, ridiculed as paranoia and, that he's just trying to evade justice, but actually he was trying to evade injustice. And the living proof of that is what happened to him since the day of his arrest in April 2019. His procedural rights have been severely violated. He has not had sufficient access to his lawyers. He has to prepare his defense. I mean, at every step, at every stage of every proceeding, his procedural rights as a defendant have been severely violated. He has been biased judges, who have been insulting him in open court. He has been, threatened basically already by the U.S., obviously during his stay in the Ecuadorian embassy. All his arguments have been, we've had the proof now on Monday, have been dismissed, although we've had about 40 expert witnesses confirming every single step based on consolidated evidence. And all of this has been just summarily dismissed to confirm a U.S. prosecution case, which is unprecedented. I mean, we could pick any of those examples, any of those arguments that have been made, and everything has just been dismissed in a manner that is not compatible with the rule of law. I'm a UK professor of law. I could never imagine that something like this could happen in the UK. If you're trying to escape that type of prosecution, which is not a prosecution on the law, it is a political persecution, well, that's what asylum is for. So obviously, it's not a crime. It's a human right to seek asylum and protection from these types of human rights abuses. And the UK has just proven in the last 18 months that Julian Assange has been right and had been right all along.
You visited Julian Assange in Belmarsh prison with a team of doctors. You saw the condition that he's in. You said he showed signs of prolonged psychological torture. The judge, she wrote in her judgment that special administrative measures would be too detrimental to Julian's mental health and that he's at risk of suicide. She also acknowledges in the same judgment, however, that he's suicidal in Belmarsh currently, and you saw him there. So how can she justify sending him back if the entire pillar of her judgment from Monday not to extradite him is based and rooted in mental health?
Yeah. Well, my own assessment very much confirms what has been said in open court in September. So I can disclose that myself as well. I mean, the day I visited him, the 9th of May, 2 days before, a razor blade had been found in his cell. And he actually talked to me about this when I visited him. And he also made very clear that he would not be extradited alive. So he has this determination. I think I would agree that probably his risk of suicide is much higher in the US than it is in the UK, because in the UK, he still has hope that he might not be extradited, and after that he would be released. And once he's in the US, he knows that he will never get out of prison again. And so it's a different kind of prospect. So I think that objectively certainly is a difference. But what has to be very clearly stated, there is no justification for him to be in a high security prison. Even if, there's no justification to prosecute him, to extradite him in the first place. But even if we leave that aside and we say that, okay, formally we have a legal proceeding, we have an appeals phase, we have to somehow ensure that he remains available for that, and he has a certain history of seeking asylum and making himself unavailable for that. Even if we recognize all of that, Belmarsh is the last place where he should be. He should be in house arrest, and you can put a guard in front of his home. Honestly, it's less expensive to do that than to put him in a high security prison with all the implications that has. And we have to understand, he's not a convict. He's not serving. He's not a criminal. He's a free citizen. Since September 2019, he should be a free citizen who is absolutely free to live a family life, a professional life, and who just has to be available at the end of the extradition proceeding if he's to be extradited. This can be ensured in a completely different way. There are more open, even in terms of prisons, any other prison would be more open than Belmarsh. So it's not a coincidence that they chose Belmarsh, because it shows that the purpose is not to keep him available for the proceeding. It is to keep him out of the public space and to keep him silenced. And that's exactly the purpose of this proceeding. I also personally don't think that the US is absolutely in a rush to get him extradited. If they can extend this proceeding another 5 years and then have him extradited and have another 5 or 10 years of proceedings in the US, and during this time they will just put him in isolation, they're just as happy. Remember the Stratfor emails of 2012 recommending that he should be prosecuted for the next 25 years from jurisdiction to jurisdiction. And that's precisely the playbook that we see playing out before our eyes now. And, some of the mainstream media are still claiming that this is about, the law and justice. And that's just very, very concerning.
Are you holding out much hope in regards to the Biden administration? Because yesterday we heard from the outgoing prosecutor of the Eastern District Court of Virginia that this Assange case has consumed a lot of time and resources. What did you make of that report? I mean, given what you just said, it's kind of clear, but...
Yeah, I think that we should give the incoming president the benefit of the doubt. Although he has been part of the Obama administration, and unfortunately, President Obama has been instrumental in destroying the rule of law and the credibility of the U.S. in terms of human rights law. I mean, we're talking about the drone killings that he has basically institutionalized, his refusal to prosecute torture by the CIA, although we have a 7,000-page report confirming all of these things. I mean, we're all complaining, and I think rightly complaining, that President Trump has pardoned these Blackwater mercenaries. But then, you know, Obama has basically pardoned everybody who has committed torture and war crimes in Iraq and refused to prosecute anybody except the few Abu Ghraib people where you just had photographic evidence and it was impossible not to prosecute them. But then he basically classified all the rest of the evidence to make sure that no one else would be prosecuted. And I mean, you know, but there where he's being hailed somehow as a human rights champion and he receives the Nobel Peace Prize on credit. But then, you know, what the reality of this is much more worrying. So obviously we all know that he conducted a veritable war against whistleblowers. And yes, he did not decide to prosecute Assange, but then also he never gave him any assurances that he would not be prosecuted, which is why for 7 years he stayed in that embassy. And the Democrats were very happy having him blocked in the embassy and incapacitated in this way, and having that threat scenario always ready in case he should leave. So, and Biden has been part of that administration. So it's open to see what he will do once he is president. It's possible that he will decide that he will not prosecute him under the Espionage Act because he doesn't want to have a confrontation with the New York Times and so on. But then he will just expand the computer fraud charges. I mean, that's a possible scenario, but we have to admit, at the moment, it's just speculation. They could be very comfortable releasing Assange based on medical grounds and keeping that kind of threat scenario pending above his head for the rest of his life, that, you know, if ever he should go back to WikiLeaks and taking up his profession again and challenge the power of the US again, they will just start this whole proceeding all over again.
Going forward, how hopeful are you that the decision not to extradite Assange will be upheld? And how hopeful are you that the decision to deny him bail will be overturned in the high courts as they're both appealed?
It's very difficult to say. I think it really, you know, if we've learned anything of the last 10 years of his persecution, is that this has never been about the law. It's not been about the law in Sweden. It's never been about protecting women, against sexual violence, which is a very important issue. But this has not been the intention of the Swedish authorities. If anything, these Swedish authorities have destroyed these women's lives as well. They never cared about that. So this has been a political persecution in Sweden already. It was a political persecution afterwards in the UK while he was in the embassy, where the UK always pushed Sweden never to drop the charges, even when Sweden wanted to drop the charges. The British, for all, I mean, they were not even involved. You know, these women were not British. It didn't happen in Britain. Why would they care? Because they had a political motivation. Britain initially even wanted to storm the Ecuadorian embassy. Remember, William Hague actually threatened to storm the Ecuadorian embassy when he sought asylum there. And that's absolutely unprecedented. You don't do that because of someone who is wanted in Sweden. And I underline, he's never been charged in Sweden. he was wanted for questioning. He was wanted for questioning. You don't storm an embassy of another country because there's someone there who is wanted for questioning in a different country. So where there is smoke, there is fire. And there's been a lot of smoke in this case. And so there is a fire that is very, very important. It was always about political motivations to silence Assange. And what happened, what the Ecuadorian government, the new government did, obviously the previous government is to be commended for standing up for the right to seek asylum. But then the Moreno government sold out Assange and expelled him without any due process. You know, even if formally you can say, yes, there can be reasons to withdraw an asylum. There can be reasons even to withdraw nationality. But then Julian Assange was his asylum and his citizenship, Ecuadorian citizenship, was terminated one morning. He was just informed and then arrested immediately. He had no possibility to defend himself. Clearly, it was not a due process proceeding. And so, and the same, the U.S. would expect him in the U.S., the espionage court. I mean, you could go to any of the proceedings that have been held there. None of it has been public. The evidence is secret. The defense doesn't have access to it. The jury is biased. The public is excluded. I mean, these are state security trials that you would have in dictatorships, but it's not something that is worthy of the rule of law. So all of this to say, this is not about the law. Even Monday's decision is not about the law. We don't know exactly what has been negotiated, behind the curtains, but there is a political motivation behind this. And unfortunately, what happens at appeal will be also governed by political motivations. Unfortunately, I think that's just the reality. And the only remedy against that is that the public becomes aware of what's going on and demands accountability and demands that the law is actually being upheld.
Definitely. We'll keep doing our best. Thanks again for your time, Professor. It's great having you on.
Thank you very much for your interest and for having me. Thank you.